A unanimous suppressor decision just dropped, and the Department of Justice did the unthinkable. They reversed their entire position, and they openly admitted that NFA suppressor regulations are unconstitutional. That changes everything for 2.6 million suppressor owners, and for every NFA item going forward. Hit subscribe right now, because what I'm about to show you will blow your mind. The DOJ reversal. What actually happened. On January 20th, 2026, Acting Associate Attorney General Benjamin Williams filed a 47-page confession of error. And in plain English, that filing admitted the federal government has been violating the Second Amendment for 90 years. This was not a quiet memo, not an internal policy tweak. This was a public court filing in United States versus Patterson. And it said the DOJ could no longer defend suppressor provisions of the National Firearms Act under the Supreme Court's Bruen standard. Here's the magnitude. These are the same attorneys who spent $400,000 in taxpayer money writing a 156-page appellate brief defending NFA suppressor regulations in September 2025. Now, those same lawyers were systematically dismantling every single argument they previously made. They admitted suppressors are in common use. With 2.6 million registered units, they conceded the $200 tax stamp functions as a financial barrier, one that prices poor Americans out of their rights. And the reversal was not limited to one case. DOJ attorneys filed notices of position change in 6 different circuit courts at the same time. They withdrew opposition to suppressor challenges from Arizona to Maine. Cases that had been in litigation for 3 years suddenly saw government lawyers filing concessions. But here's what makes this reversal so calculated. The DOJ specifically stated this confession applies only to suppressors, and it should not be read as abandoning defense of machine guns, short-barreled rifles, or destructive devices. The government was making a strategic retreat on the most sympathetic NFA category. Why? To prevent something far worse. And that's where the Ninth Circuit panel refused to play along. The Patterson case. How we got here. Michael Patterson wasn't trying to become some constitutional test case plaintiff. He's a competitive shooting instructor in Scottsdale, Arizona. He runs a firearms training academy for law enforcement and civilians. In March 2024, he purchased a silencer Comeri Omega 9K suppressor for $650. And he bought it for one reason: to protect his hearing. After 15 years of instruction, he already had permanent damage. If you've ever spent full days on a range, with rifles going off all around you, you already understand how fast that adds up. Patterson followed every legal requirement the ATF demanded. He paid the $200 tax stamp. He submitted fingerprints and photographs. He provided passport-style photos. He notified his county sheriff. And he waited. His application sat in the ATF National Firearms Act Division for 11 months and 17 days before approval finally came through. That wait is the story, and it matters. The Firearms Policy Coalition approached Patterson about challenging not just the waiting period, but the entire constitutional basis for the NFA suppressor framework. Patterson agreed, but with one condition. The case had to seek relief for all suppressor owners, not just him. The complaint filed in the District of Arizona didn't ask for minor reforms. It didn't ask for incremental changes. District Court Judge Sarah Henderson agreed. She issued a 73-page opinion in September 2024, finding suppressors clearly meet constitutional protection under Bruen. But that's when the real fight began, because the DOJ immediately appealed to the most anti-gun circuit court in America. The Ninth Circuit nightmare. Why everyone expected to lose. The Ninth Circuit Court of Appeals has a reputation that makes Second Amendment attorneys physically uncomfortable. Before this decision, the circuit had ruled against gun rights claims in 23 consecutive cases since the Bruen decision came down in June 2022. They upheld California's assault weapon ban, magazine capacity limits, ammunition background check requirements. They even upheld a ban on firearm advertising visible from public streets. Then the 3-judge panel assignment made it worse. Judge Paul Watford had previously written opinions upholding California's 10-day waiting period for all gun purchases, even for people who already own firearms. Judge Andrew Hurwitz authored the decision upholding Hawaii's ban on openly carrying firearms in public. Judge Jacqueline Nguyen had never voted to strike down a single gun regulation in her entire judicial career. Gun rights organizations knew they were walking into an ambush. The Second Amendment Foundation allocated $280,000 for the appeal. They expected they'd lose at the circuit level and need resources for a Supreme Court petition. The Firearms Policy Coalition wargame scenarios where the Ninth Circuit would not only uphold the NFA provisions, but issue an opinion so hostile to gun rights it would actually make things worse by creating bad precedent. The oral argument was scheduled for January 28, 2026. Everyone expected a disaster. Then the government's confession of error filed on January 20th meant oral argument never happened. And instead of the expected loss, Patterson won everything. What do you think forced the DOJ to reverse their position? Internal legal analysis, political pressure, or fear of losing even bigger at the Supreme Court? Drop your theory in the comments. The Bruen Standard, the test the government couldn't pass. The Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruen fundamentally changed how courts analyze gun regulations. And that's exactly why the DOJ couldn't defend suppressors anymore. Before Bruen, courts used a two-step test. First, does the Second Amendment apply? Second, does the regulation survive means in scrutiny? That means the court balanced government interests against individual rights. Bruen eliminated balancing entirely. Justice Clarence Thomas wrote for the majority that the Second Amendment is not a second-class right subject to interest balancing. Instead, courts must apply a text, history, and tradition test. First, does the Second Amendment's plain text cover the regulated conduct? If yes, the government must prove the regulation is consistent with the nation's historical tradition of firearms regulation from the founding era. And that creates an impossible problem for the NFA. Suppressors weren't invented until 1902, when Hiram Percy Maxim patented the first commercially successful design. There literally cannot be regulations of suppressors from 1791, because they didn't exist yet. The DOJ tried to argue that historical regulations of other dangerous items, like gunpowder storage, could serve as analogs. But the Bruen Standard requires the historical regulation be relevantly similar. Similar in how it burdens the right, and similar in why it burdens the right. The government's own Office of Legal Counsel spent 7 months searching for historical analogs that could justify suppressor registration and taxation. They found nothing that survived scrutiny. A $200 tax on a hearing protection device has no historical parallel to anything from the founding era. And that's why the DOJ had to confess error. Rather than defend the indefensible, the unanimous opinion, 3 pillars that destroyed the NFA. Chief Judge Jacqueline Nguyen's 89-page opinion is a constitutional masterpiece. Gun rights attorneys are already calling it the most important Second Amendment decision since Heller. All 3 judges joined every section. That makes it binding precedent across 9 Western states. The opinion rests on 3 independent pillars. Each one by itself is sufficient to strike down the suppressor provisions. Pillar 1, common use. The government argued that 2.6 million suppressors sounds like a lot, but it represents only 2% of gun owners, making them unusual. Judge Nguyen demolished that. She pointed out that when Heller was decided in 2008, there were approximately 1.5 million AR-15 rifles in civilian hands. Yet the court specifically cited AR-15s as protected arms in common use. Pillar 2. The tax is a prior restraint. The court found $200 in 1934 is equivalent to $4,600 today when adjusted for inflation. The average suppressor costs $600, meaning the tax is 8 times the value of the item being taxed. No other constitutional right can be taxed at 800%. Pillar 3. The waiting period is a de facto ban. The court found a 9 to 12-month delay in exercising a constitutional right, with no maximum time limit and no recourse if the government simply never processes the application, constitutes a de facto ban. Patterson waited 11 months for approval after already passing a background check that took 15 minutes. The 90-day implementation order. What changes immediately? Judge Nguyen didn't just strike down the law and create chaos. The opinion includes a detailed 90-day implementation timeline. It phases out NFA suppressor requirements while maintaining background checks through the existing NICS system. Effective immediately as of January 23, 2026, the ATF must stop collecting $200 tax stamps. Anyone buying a suppressor after this date pays only for the suppressor itself, and they undergo a standard NICS background check identical to purchasing a handgun. No fingerprints, no photographs, no ATF Form 4, no chief law enforcement officer notification, and no waiting period beyond the instant background check processing time. For the 347,000 people currently waiting on pending Form 4 applications submitted before January 23rd. The ATF has 14 days to auto-approve pending applications, pending a successful NICS recheck. Within 90 days, the ATF must refund all $200 tax stamp payments for applications submitted after January 1st, 2024. That's approximately $69.4 million in refunds. Most significantly, lawful gun owners are deemed lawful possessors of suppressors without registration. That means if you legally own guns now, you can legally own suppressors now. The NFA registry for suppressors becomes obsolete. Do you think this implementation timeline is realistic? Or is the ATF going to fight this and cause chaos? Let me know in the comments what you think happens when April 23rd arrives. The domino effect. Short-barreled rifles are next. The opinion's legal reasoning doesn't stop at suppressors, and the court knew it. Judge Nguyen included a 20-page section of dicta, not necessary to the decision, but it provides guidance for future cases, and it systematically applies the same Bruen analysis to short-barreled rifles and shotguns. The implications are devastating for what remains of the NFA. Short-barreled rifles, defined as rifles with barrels under 16 inches, have been NFA items since 1934. The government's historical justification has always been that SBRs are concealable and therefore more dangerous than full-length rifles. But the opinion points out that millions of Americans legally carry concealed handguns in all 50 states after Bruen struck down May issue permitting. The opinion cites data showing approximately 4.2 million AR-15 pistols and braced firearms in civilian hands, all with barrels under 16 inches. These are already in common use for lawful purposes, including home defense. Judge Nguyen wrote she could find no principled distinction between an AR-15 pistol with a 13-inch barrel and an AR-15 rifle with a 13-inch barrel, except that one requires a $200 tax and one doesn't. 3 separate SBR lawsuits were filed within 18 hours, all in the Ninth Circuit. They're doing it to take advantage of binding precedent. Legal experts give these cases a 95% probability of success because the government already admitted they can't defend arbitrary barrel length restrictions under Bruen. The state law complication. 8 states still ban suppressors. Here's the problem nobody's talking about. This is a federal court decision striking down federal law. 8 states have their own suppressor bans written into state criminal codes. They exist independently of the NFA. So if you live in California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, or Hawaii, you're still violating state law if you possess a suppressor, even though federal law no longer prohibits it. California Penal Code Section 33410 makes it a felony to possess a silencer, with penalties up to 3 years in state prison. New York Penal Law 265.10 classifies suppressors as dangerous weapons with a mandatory minimum sentence. These state laws were written to mirror federal NFA restrictions, but they remain on the books as independent criminal statutes. However, the legal pathway is clear. The 14th Amendment binds the states to the Second Amendment. If the federal NFA suppressor provisions violate the Second Amendment, then identical state provisions also violate the Second Amendment. The timeline for state-level relief is faster than most people realize. California already has a pending suppressor ban challenge that was stayed waiting for developments in federal NFA litigation. Gun rights attorneys estimate that state suppressor bans in at least 5 of the 8 states will fall within 12 months. The machine gun question, the Hughes Amendment under attack, the question everyone's asking. Does this decision open the door to challenging the machine gun ban? The answer is complicated, but yes, challenges are already being drafted. The 1986 Firearm Owners Protection Act included the Hughes Amendment. It prohibits civilian possession of machine guns manufactured after May 19, 1986. That created a closed registry. Only approximately 630,000 transferable machine guns exist, and that scarcity drives prices to $15,000 to $40,000 for weapons that cost $600 to manufacture. The constitutional analysis for machine guns is harder than suppressors because of United States versus Miller from 1939. That case stated the Second Amendment protects weapons with a reasonable relationship to militia use. Machine guns are clearly militia weapons. They're standard issue for every military force on Earth. But Miller also said weapons must be in common use, and the Hughes Amendment has artificially prevented machine guns from being in common use by freezing the supply for 40 years. Here's where Patterson creates an opening. The opinion states the government can't call something unusual when the government's own rules prevent it from becoming common. That exact reasoning applies to machine guns. Before 1986, machine gun registrations were growing at 15,000 to 20,000 per year. If that growth had continued, there would be over 1.2 million registered machine guns today. That would easily meet the common use threshold. Second, Patterson holds that registration and taxation requirements are unconstitutional prior restraints. The Hughes Amendment doesn't just tax or register machine guns, it bans them entirely for civilians. If a $200 tax and registration violates the Second Amendment, an absolute ban certainly does. The Firearms Policy Coalition has confirmed they're preparing a Hughes Amendment challenge to be filed in the Fifth Circuit, the most gun-friendly appellate court. They're recruiting plaintiffs who are FFL manufacturers currently allowed to possess post-1986 machine guns for dealer samples. This is the ultimate question. Do you think the Hughes Amendment machine gun ban will survive constitutional scrutiny after Patterson? Or is the NFA completely finished? Comment your prediction below, because this is the most consequential Second Amendment question of our generation. The NFA is crumbling in real time, and most gun owners have no idea this is happening. If you want to stay ahead of every major development in firearms law, hit that subscribe button and turn on notifications right now. Like this video, share it with every gun owner you know, and I'll see you in the next one.